number 2031, the Negotiable Instruments Law, Form and Interpretation. Section 1, Form of Negotiable Instruments. An instrument to be negotiable must conform to the following requirements. A. It must be in writing and signed by the maker or drawer. B. Must contain an unconditional promise or order to pay a sum certain in money. C. Must be payable on demand or at a fixed or determinable future time. D. Must be payable to order or to bearer. And lastly, letter E, where the instrument is addressed to a drawee, he must be named or otherwise indicated therein with reasonable certainty. Section 2. What constitutes certainty as to sum? The sum payable is a sum certain within the meaning of this act, although it is to be paid, letter A, with interest, or letter B, by stated installments, or letter C, by stated installments with a provision that upon default in payment of any installment or interest, the whole shall become due, or letter D, with exchange whether at a fixed rate or at the current rate, or letter E, with costs of collection or an attorney's fee in case payment shall not be made at maturity. Section 3, when promise is unconditional. An unqualified order or promise to pay is unconditional within the meaning of this act, though coupled with, letter A, an indication of a particular fund out of which reimbursement is to be made or at a particular account to be debited with the amount, or letter B, a statement of the transaction which gives rise to the instrument. But an order or promise to pay out of a particular fund is not unconditional. Section 4. Determinable future time. What constitutes? An instrument is payable at a determinable future time within the meaning of this act, which is expressed to be payable, letter A, at a fixed period after date or site, or letter B, on or before a fixed or determinable future time specified therein, or letter C, on or at a fixed period after the occurrence of a specified event which is certain to happen, though the time of happening be uncertain. An instrument payable upon a contingency is not negotiable, and the happening of the event does not cure the defect. Section 5. Additional provisions not affecting negotiability. An instrument which contains an order or promise to do any act in addition to the payment of money is not negotiable. But the negotiable character of an instrument, otherwise negotiable, is not affected by a provision which, letter A, authorizes the sale of collateral securities in case the instrument be not paid at maturity, or letter B, authorizes a confession of judgment if the instrument be not paid at maturity, or letter C, waives the benefit of any law intended for the advantage or protection of the obligor, or letter D, gives the holder an election to require something to be done in lieu of payment of money. But nothing in this section shall validate any provision or stipulation otherwise illegal. Section 6. Omissions, seal, particular money. The validity and negotiable character of an instrument are not affected by the fact that, letter A, it is not dated, or letter B, does not specify the value given, or that any value had been given therefore, or letter C, does not specify the place where it is drawn or the place where it is payable, or letter D, bears a seal, or letter E, designates a particular kind of current money in which payment is to be made. But nothing in this section shall alter or repeal any statute requiring in certain cases the nature of the consideration to be stated in the instrument. Section 7. When payable on demand. An instrument is payable on demand, letter A, when it is so expressed to be payable on demand or at sight or on presentation. Or B, in which no time for payment is expressed. Where an instrument is issued, accepted, or endorsed when overdue, it is, as regards the person so issuing, accepting, or endorsing it, payable on demand. Section 8. When payable to order. The instrument is payable to order where it is drawn payable to the order of a specified person or to him, or his order. It may be drawn payable to the order of letter A payee who is not maker, drawer, or drawee, or letter B, the drawer or maker, or letter C, the drawee, or letter D, two or more payees jointly, or letter E, one or some of several payees, or letter F, the holder of an office for the time being. Where the instrument is payable to order, the payee must be named or otherwise indicated therein with reasonable certainty. Section 9. When payable to bearer. The instrument is payable to bearer, letter A, when it is expressed to be so payable, or letter B, when it is payable to a person named therein, or bearer, or letter C, when it is payable to the order of a fictitious or non-existing person and such fact was known to the person making it so payable, or letter D, when the name of the payee does not purport to be the name of any person, or letter E, when the only or last endorsement is an endorsement in blank. Section 10. Terms whence sufficient. The instrument need not follow the language of this act, but any terms are sufficient, which clearly indicate an intention to conform to the requirements hereof. Section 11. Date presumption as to. Where the instrument or an acceptance or any endorsement thereon is dated, such date is deemed prima facie to be the true date of the making, drawing, acceptance, or endorsement as the case may be. Section 12. Antedated and postdated. The instrument is not invalid for the reason only that it is undated or postdated, provided this is not done for an illegal or fraudulent purpose. The person to whom an instrument so dated is delivered acquires the title thereto as of the date of delivery. Section 13. When date may be inserted. Where an instrument expressed to be payable at a fixed period after date is issued undated, or where the acceptance of an instrument payable at a fixed period after sight is undated, any holder may insert therein the true date of issue or acceptance, and the instrument shall be payable accordingly. The insertion of a wrong date does not avoid the instrument in the hands of a subsequent holder in due course, but as to him, the date so inserted is to be regarded as the true date. Section 14. Blanks when may be filled. Where the instrument is wanting in any material particular, the person in possession thereof has a prima facie authority to complete it by filling up the blanks therein, and a signature on a blank paper delivered by the person making the signature in order that the paper may be converted into a negotiable instrument operates as a prima facie authority to fill it up as such for any amount. In order, however, that any such instrument when completed may be enforced against any person who became a party thereto prior to its completion, it must be filled up strictly in accordance with the authority given and within a reasonable time. But if any such instrument after completion is negotiated to a holder in due course, it is valid and effectual for all purposes in his hands, and he may enforce it as if it had been filled up strictly in accordance with the authority given and within a reasonable time. Section 15. Incomplete instrument not delivered. Where an incomplete instrument has not been delivered, it will not, if completed and negotiated without authority, be a valid contract in the hands of any holder, as against any person whose signature was placed thereon before delivery. Section 16. Delivery when effectual, when presumed. Every contract on a negotiable instrument is incomplete and revocable until delivery of the instrument for the purpose of giving effect thereto. As between immediate parties and as regards a remote party, other than a holder in due course, the delivery, in order to be effectual, must be made either by or under the authority of the party making, drawing, accepting, or endorsing, as the case may be. And in such case, the delivery may be shown to have been conditional or for a special purpose only, and not for the purpose of transferring the property in the instrument. But, where the instrument is in the hands of a holder in due course, a valid delivery thereof by all parties prior to him, so as to make them liable to him, is conclusively presumed. And where the instrument is no longer in the possession of a party whose signature appears thereon, a valid and intentional delivery by him is presumed until the contrary is proved. Section 17. Construction where instrument is ambiguous. Where the language of the instrument is ambiguous or there are omissions therein, the following rules of construction apply. Letter A, where the sum payable is expressed in words and also in figures, and where there is a discrepancy between the two, the sum denoted by the words is the sum payable. But if the words are ambiguous or uncertain, reference may be had to the figures to fix the amount. Letter B, where the instrument provides for the payment of interest without specifying the date from which interest is to run, the interest runs from the date of the instrument, and if the instrument is undated, from the issue thereof. Letter C, where the instrument is not dated, it will be considered to be dated as of the time it was issued. Letter D, where there is a conflict between the written and printed provisions of the instrument, the written provisions prevail. Letter E, where the instrument is so ambiguous that there is doubt whether it is a bill or note, the holder may treat it as either at his election. Letter F, where a signature is to be placed upon the instrument that it is not clear in what capacity the person making the same intended to sign, he is to be deemed an endorser. Letter G, where an instrument containing the word "I promise to pay" is signed by two or more persons, they are deemed to be jointly and severally liable thereon. Section 18. Liability of person signing in trade or assumed name. No person is liable in the instrument whose signature does not appear thereon, except as herein otherwise expressly provided, but one who signs in a trade or assumed name will be liable to the same extent as if he had signed his own name. Section 19. Signature by agent, authority, how shown. The signature of any party may be made by a duly authorized agent. No particular form of appointment is necessary for this purpose, and the authority of the agent may be established as in other cases of agency. Section 20. Liability of persons signing as agents and so forth. Where the instrument contains or a person adds to his signature words indicating that he signs for or on behalf of a principal or in a representative capacity, he is not liable on the instrument if he was duly authorized, but the mere addition of words describing him as an agent or as filling a representative character without disclosing his principal does not exempt him from personal liability. Section 21. Signature by procuration, effect of. A signature by procuration operates as notice that the agent has but a limited authority to sign, and the principal is bound only in case the agent, in so signing, act acted within the actual limits of his authority. Section 22. Effect of endorsement by infant or corporation. The endorsement or assignment of the instrument by a corporation or by an infant passes the property therein, notwithstanding that from want of capacity, the corporation or infant may incur no liability thereon. Section 23. Forged signature effect of. When a signature is forged or made without the authority of the person whose signature it purports to be, it is wholly inoperative, and no right to retain the instrument or to give a discharge therefore or to enforce payment thereof against any party thereto can be acquired through or under such signature, unless the party against whom it is sought to enforce such right is precluded from setting up the forgery or want of authority. Part 2 is all about the consideration. Section 24, Presumption of consideration. Every negotiable instrument is deemed a prima facie to have been signed. Section 24, Presumption of consideration. Every negotiable instrument is deemed a prima facie to have been issued for a valuable consideration, and every person whose signature appears thereon to have become a party thereto for value. Section 25, Value, what constitutes. Value is any consideration sufficient to support a simple contract. An antecedent or pre-existing debt constitutes value, and is deemed such whether the instrument is payable on demand or at a future time. Section 26. What constitutes holderful value? Where the value has at any time been given for the instrument, the holder is deemed a holder for value in respect to all parties who become such prior to that time. Section 27. When lien on instrument constitutes holder for value. Where the holder has a lien on the instrument arising either from contract or by implication of law, he is deemed a holder for value to the extent of his lien. Section 28. Effect of want of consideration. Absence or failure of consideration is a matter of defense as against any person not a holder in due course, and partial failure of consideration is a defense pro tanto, whether the failure is an ascertained and liquidated amount or otherwise. Section 29. Liability of accommodation party. An accommodation party is one who has signed the instrument as maker, drawer, acceptor, or endorser without receiving value therefor, and for the purpose of lending his name to some other person. Such a person is liable on the instrument to a holder for value, notwithstanding such holder, at the time of taking the instrument, knew him to be only an accommodation party. Part 3. Negotiation. Section 30. What constitutes negotiation? An instrument is negotiated when it is transferred from one person to another in such manner as to constitute the transferee the holder thereof. If payable to bearer, it is negotiated by delivery. If payable to order, it is negotiated by the endorsement of the holder and completed by delivery. Section 31. Endorsement. How made? The endorsement must be written on the instrument itself or upon a paper attached thereto. The signature of the endorser without additional words is a sufficient endorsement. Section 32. Endorsement must be of entire instrument. The endorsement must be an endorsement of the entire instrument. An endorsement which purports to transfer to the endorsee a part only of the amount payable, or which purports to transfer the instrument of two or more endorsees severally, does not operate as a negotiation of the instrument, but where the instrument has been paid in part, it may be endorsed as to the residue. Section 33. Kinds of endorsement. An endorsement may be either special or in blank, and it may also be either restrictive or qualified or conditional. Section 34. Special endorsement. Endorsement in blank. A special endorsement specifies the person to whom or to whose order the instrument is to be payable, and the endorsement of such endorsee is necessary to the further negotiation of the instrument. An endorsement in blank specifies no endorsee, and an instrument so endorsed is payable to bearer and may be negotiated by delivery. Section 35. Blank endorsement. How changed to special endorsement. The holder may Convert a blank endorsement into a special endorsement by writing over the signature of the endorser in blank any contract consistent with the character of the endorsement. Section 36. When endorsement restrictive. An endorsement is restrictive, which either prohibits the further negotiation of the instrument, or letter B, constitutes the endorsee the agent of the endorser, or letter C, vests the title in the endorsee in trust for or to the use of some other persons. But the mere absence of words implying power to negotiate does not make an endorsement restrictive. Section 37. Effect of restrictive endorsement. Right of endorsee. A restrictive endorsement confers upon the endorsee the right: A. To receive payment of the instrument. B. To bring any action thereon that the endorser could bring. C. To transfer his rights as such endorsee where the form of the endorsement authorizes him to do so. But all subsequent endorsees acquire only the title of the first endorsee under the restrictive endorsement. Section 38. Qualified endorsement. A qualified endorsement constitutes the endorser a mere assigner of the title to the instrument. It may be made by adding to the endorser's signature the words "without recourse" or any words of similar import. Such an endorsement does not impair the negotiable character of the instrument. Section 39. Conditional endorsement. Where an endorsement is conditional, the party required to pay the instrument may disregard the condition and make payment to the endorsee or his transferee, whether the condition has been fulfilled or not. But any person to whom an instrument so endorsed is negotiated will hold the same or the proceeds thereof, subject to the rights of the person endorsing conditionally. Section 40. Endorsement of instrument payable to bearer. Where an instrument payable to bearer is endorsed specially, it may nevertheless be further negotiated by delivery, but the person endorsing specially is liable as endorser to only such holders as make title through his endorsement. Section 41. Endorsement where payable to two or more persons. Where an instrument is payable to the order of two or more payees or endorsees who are not partners, all must endorse unless the one endorsing has authority to endorse for the others. Section 42. Effect of instrument drawn or endorsed to a person as cashier. Where an instrument is drawn or endorsed to a person as cashier or other fiscal officer of a bank or a corporation, it is deemed prima facie to be payable to the bank or corporation of which he is such officer, and may be negotiated by either the endorsement of the bank or corporation or the endorsement of the officer. Section 43. Endorsement where name is misspelled and so forth. Where the name of a payee or endorsee is wrongly designated or misspelled, he may endorse the instrument as therein described, adding, if he thinks fit, his proper signature. Section 44. Endorsement in representative capacity. Where any person is under obligation to endorse in a representative capacity, he may endorse in such terms as to negative personal liability. Section 45. Time of endorsement presumption. Except where an endorsement bears date after the maturity of the instrument, every negotiation is deemed prima facie to have been effected before the instrument was overdue. Section 46. Place of endorsement presumption. Except where the contrary appears, every endorsement is presumed prima facie to have been made at the place where the instrument is dated. Section 47. Continuation of negotiable character. An instrument negotiable in its origin continues to be negotiable until it has been restrictively endorsed or discharged by payment or otherwise. Section 48. Striking out endorsement. The holder may at any time strike out any endorsement which is not necessary to his title. The endorser whose endorsement is struck out and all endorsers subsequent to him are thereby relieved from liability on the instrument. Section 49. Transfer without endorsement effect of. where the holder of an instrument payable to his order transfers it for value without endorsing it, the transfer vests in the transferee such title as the transferor had therein, and the transferee acquires in addition the right to have the endorsement of the transferor. But for the purpose of determining whether the transferee is a holder in due course, the negotiation takes effect as of the time when the endorsement is actually made. Section 50. When prior party may negotiate instrument. Where an instrument is negotiated back to a prior party, such party may, subject to the provisions of this act, reissue and further negotiate the same. But he is not entitled to enforce payment thereof against any intervening party to whom he was personally liable. Next chapter is all about the rights of the holder. Section 51, the right of holder to sue. Payment. The holder of a negotiable instrument may sue thereon in his own name, and payment to him in due course discharges the instrument. Section 52. What constitutes a holder in due course? A holder in due course is a holder who has taken the instrument under the following conditions. That, letter A, it is complete and regular upon its face. B, that he became the holder of it before it was overdue, and without notice that it had been previously dishonored if such was the fact. Letter C, that he took it in good faith and for value. And letter D, that at the time it was negotiated to him, he had no notice of any infirmity in the instrument or defect in the title of the person negotiating it. Section 53. Where person not deemed holder in due course. Where an instrument payable on demand is negotiated an unreasonable length of time after its issue, the holder is not deemed a holder in due course. Section 54. Notice before full amount paid. Where the transferee receives notice of any infirmity in the instrument or defect in the title of the person negotiating the same, before he has paid the full amount agreed to be paid, therefore, he will be deemed a holder in due course only to the extent of the amount theretofore paid by him. Section 55. When title is defective. The title of a person who negotiates an instrument is defective within the meaning of this act when he obtained the instrument or any signature thereto by fraud, duress, or force, in fear, or other unlawful means, or for an illegal consideration, or when he negotiates it in breach of faith, or under such circumstances as amount to a fraud. Section 56. What constitutes notice of defect? To constitute notice of an infirmity in the instrument or defect in the title of the person negotiating the same, the person to whom it is negotiated must have had actual knowledge of the infirmity or defect or knowledge of such facts that his action in taking the instrument amounted to bad faith. Section 57. The rights of holder in due course. A holder in due course holds the instrument free from any defect of title of prior parties and free from defenses available to prior parties among themselves, and may enforce payment of the instrument for the full amount thereof against all the parties liable thereon. Section 58. When subject to original defenses. In the hands of any holder other than the holder in due course, a negotiable instrument is subject to the same defenses as if it were non-negotiable. But a holder who derives his title through a holder in due course, and who is not himself a party to any fraud or illegally affecting the instrument, has all the rights of such former holder in respect of all parties prior to the latter. Section 59. Who is deemed holder in due course? Every holder is deemed prima facie to be a holder in due course. But when it is shown that the title of any person who has negotiated the instrument was defective, the burden is on the holder to prove that he or some person under whom he claims acquired the title as a holder in due course. But the last mentioned rules does not apply in favor of a party who became bound on the instrument prior to the acquisition of such defective title. Section 60. Liabilities of parties. Next chapter is liabilities of parties. Section 60. Liability of maker. The maker of a negotiable instrument, by making it, engages that he will pay it according to its tenor and admits the existence of the payee and his then capacity to endorse. Section 61. Liability of drawer. The drawer, by drawing the instrument, admits the existence of the payee and his then capacity to endorse, and engages that on due presentment, the instrument will be accepted or paid, or both, according to its tenor, and that if it be dishonored and the necessary proceedings on dishonor be duly taken, he will pay the amount thereof to the holder or to any subsequent endorser who may be compelled to pay it. But the drawer may insert in the instrument an express stipulation negativing or limiting his own liability to the holder. Section 62. The liability of acceptor. The acceptor, by accepting the instrument, engages that he will pay it according to the tenor of his acceptance and admits A. The existence of the drawer and the genuineness of his signature and his capacity and authority to draw the instrument, and letter B. The existence of the payee and his then capacity to endorse. Section 63. When person deemed endorser. A person placing his signature upon an instrument otherwise than as maker, drawer, or acceptor is deemed to be an endorser, unless he clearly indicates by appropriate words his intention to be bound in some other capacity. Section 64. Liability of irregular endorser. Where a person not otherwise a party to an instrument places thereon his signature in blank before delivery, he is liable as endorser in accordance with the following rules. A. If the instrument is payable to the order of a third person, he is liable to the payee and to all subsequent parties. B. If the instrument is payable to the order of the maker or drawer, or is payable to bearer, he is liable to all parties as subsequent to the maker or drawer. Letter C. If he signs for the accommodation of the payee, he is liable to all parties subsequent to the payee. Section 65. Warranty where negotiation by delivery and so forth. Every person negotiating an instrument by delivery or by a qualified endorsement warrants that A. The instrument is genuine and in all respects what it purports to be. B. That he has good title to it. C. That all parties or all prior parties had capacity to contract. D. That he has no knowledge of any fact which would impair the validity of the instrument or render it valueless. But when the negotiation is by delivery only, the warranty extends in favor of no holder other than the immediate transferee. The provisions of subdivision C of this section do not apply to persons negotiating public or corporation securities other than bills and notes. Section 66. Liability of general endorser. Every endorser who endorses without qualification warrants to all subsequent holders in due course. A. The matters and things mentioned in subdivisions A, B, and C of the next preceding section. And B. That the instrument is at the time of his endorsement valid and subsisting. And in addition, he engages that on due presentment, it shall be accepted or paid or both, as the case may be, according to its tenor, and that if it be dishonored and the necessary proceedings on dishonor be duly taken, he will pay the amount thereof to the holder or to any subsequent endorser who may be compelled to pay it. Section 67. Liability of endorser. Where paper negotiable by delivery. Where a person places endorsement on an instrument negotiable by delivery, he incurs all the liabilities of an endorser. Section 68. Order in which endorsers are liable. As respects one another, endorsers are liable prima facie in the order in which they endorse. But evidence is admissible to show that as between or among themselves, they have agreed otherwise. Joint payees or joint endorsees who endorse are deemed to endorse jointly and severally. Section 69. Liability of an agent or broker. Where a broker or other agent negotiates an instrument without endorsement, he incurs all the liabilities prescribed by Section 65 of this Act, unless he discloses the name of his principal and the fact that he is acting only as agent. Section 70. Presentment for payment. Effect of want of demand on the principal debtor. Presentment for payment is not necessary in order to charge the person primarily liable on the instrument. But if the instrument is by its terms payable at a special place and he is able and willing to pay it there at maturity, such ability and willingness are equivalent to a tender of payment upon his part. But, except as herein otherwise provided, presentment for payment is necessary in order to charge the drawer and endorsers. Section 71. Presentment where instruments is not payable on demand and where payable on demand. Where the instrument is not payable on demand, presentment must be made on the day it falls due. Where it is payable on demand, presentment must be made within a reasonable time after its issue, except that in the case of a bill of exchange, presentment for payment will be sufficient if made within a reasonable time after the last negotiation thereof. Section 72. What constitutes a sufficient presentment? Presentment for payment to be sufficient must be made A. By the holder or by some person authorized to receive payment on his behalf. B. At a reasonable hour on a business day. C. At a proper place as herein defined. D. To the person primarily liable on the instrument, or if he is absent or inaccessible, to any person found at a place where the presentment is made. Section 73. Place of presentment. Presentment for payment is made at the proper place, A. Where a place for payment is specified in the instrument and it is there presented. B. Where no place of payment is specified, but the address of the person to make the payment is given in the instrument and it is there presented. C. Where no place of payment is specified and no address is given and the instrument is presented at the usual place of business or residence of the person to make payment. Letter D. In any other case, if presented to the person to make payment wherever he can be found, or if presented at his last known place of business or residence. Section 74. Instrument must be exhibited. The instrument must be exhibited to the person from whom payment is demanded, and when it is paid, must be delivered up to the party paying it. Section 75. Presentment where instrument payable at bank. Where the instrument is payable at a bank, presentment for payment must be made during banking hours unless the person to make payment has no funds there to meet it at any time during the day, in which case presentment at any hour before the bank is closed on that day is sufficient. Section 76. Presentment where principal debtor is dead. Where the person primarily liable on the instrument is dead and no place of payment is specified, presentment for payment must be made to his personal representative if such there be, and if with the exercise of reasonable diligence he can be found. Section 77. Presentment to persons liable as partners. Where the persons primarily liable on the instrument are liable as partners and no place of payment is specified, presentment for payment may be made to any one of them, even though there has been a dissolution of the firm. Section 78. Presentment to joint debtors. Where there are several persons, not partners, primarily liable on the instrument and no place of payment is specified, presentment must be made to them all. Section 79. When presentment not required to charge the drawer. Presentment for payment is not required in order to charge the drawer where he has no right to expect or require that the drawee or acceptor will pay the instrument. Section 80. When presentment not required to charge the endorser. Presentment for payment is not required in order to charge an endorser where the instrument was made or accepted for his accommodation and he has no reason to expect that the instrument will be paid if presented. Section 81. When delay in making presentment is excused. Delay in making presentment for payment is excused when the delay is caused by circumstances beyond the control of the holder and not imputable to his default, misconduct, or negligence. When the cause of the delay ceases to operate, presentment must be made with reasonable diligence. Section 82. When presentment may be dispensed with. Presentment for payment is dispensed with A. Where, after the exercise of reasonable diligence, presentment as required by this act cannot be made. B. Where the drawee is a fictitious person. C. By waiver of presentment, express or implied. Section 83. When instrument dishonored by non-payment. The instrument is dishonored by non-payment when A. It is duly presented for payment and payment is refused or cannot be obtained. Letter B. Presentment is excused and the instrument is overdue and unpaid. Section 84. Liability of person secondarily liable when instrument is dishonored. Subject to the provisions of this act, when the instrument is dishonored by non-payment, an immediate right of recourse to all parties as secondarily liable thereon accrues to the holder. Section 85. Time of maturity. Every negotiable instrument is payable at the time fixed therein without grace. When the day of maturity falls upon Sunday or holiday, the instrument is payable on the next succeeding business day. Instruments falling due or becoming payable on Saturday are to be presented for payment on the next succeeding business day, except that instruments payable on demand may, at the option of the holder, be presented for payment before 12 o'clock noon on Saturday when that entire day is not a holiday. Section 86. Time, how computed. Where the instrument is payable at a fixed period after date, after sight, or after the happening of a specified event. The time of payment is determined by excluding the day from which time is to begin to run and by including the date of payment. Section 87. Rule where instrument payable at bank. Where the instrument is made payable at a bank, it is equivalent to an order to the bank to pay the same for the account of the principal debtor thereon. Section 88. What constitutes payment in due course? Payment is made in due course when it is made at or after the maturity of the instrument to the holder thereof in good faith and without notice that his title is defective. Next chapter is all about the notice of dishonor. Section 89. To whom notice of dishonor must be given, except as herein otherwise provided when a negotiable instrument has been dishonored by non-acceptance or non-payment. Notice of dishonor must be given to the drawer and each endorser, and any drawer or endorser to whom such notice is not given is discharged. Section 90. By whom given. The notice may be given by or on behalf of the holder, or by or on behalf of any party to the instrument who might be compelled to pay it to the holder, and who upon taking it up would have a right to reimbursement from the party to whom the notice is given. Section 91. Notice given by agent. Notice of dishonor may be given by an agent either in his own name or in the name of any party entitled to give notice, whether that party be his principal or not. Section 92. Effect of notice on behalf of holder. Where notice is given by or on behalf of the holder, it inures to the benefit of all subsequent holders and all prior parties who have a right of recourse against the party to whom it is given. Section 93. Effect where notice is given by party entitled thereto. Where notice is given by or on behalf of a party entitled to give notice, it inures to the benefit of the holder and all parties subsequent to the party to whom notice is given. Section 94. When agent may give notice. Where the instrument has been dishonored in the hands of an agent, he may either himself give notice to the parties liable thereon, or he may give notice to the principal. If he gives notice to his principal, he must do so within the same time as if he were the holder, and the principal, upon the receipt of such notice, has himself the same time for giving notice as if the agent had been an independent holder. Section 95. When notice sufficient. A written notice need not be signed, and an insufficient written notice may be supplemented and validated by verbal communication. A misdescription of the instrument does not vitiate the notice unless the party to whom the notice is given is in fact misled thereby. Section 96. form of notice. The notice may be in writing or merely oral and may be given in any terms which sufficiently identify the instrument and indicate that it has been dishonored by non-acceptance or non-payment. It may, in all cases, be given by delivering it personally or through the mails. Section 97, to whom notice may be given. Notice of dishonor may be given either to the party himself or to his agent in that behalf. Section 98, notice where party is dead. When any party is dead and his death is known to the party giving notice, the notice must be given to a personal representative, if there be one, and if with reasonable diligence he can be found. If there be no personal representative, notice may be sent to the last residence or last place of business of the deceased. Section 99, notice to partners, where the parties to be notified are partners. Notice to any one partner is notice to the firm, even though there has been a dissolution. Section 100, notice to persons jointly liable. Notice to joint parties who are not partners must be given to each of them unless one of them has authority to receive such notice for the others. Section 101, notice to bankrupt. Where a party has been adjudged a bankrupt or an insolvent or has made an assignment for the benefit of creditors, notice may be given either to the party himself or to his trustee or assignee. Section 102, time within which notice must be given. Notice may be given as soon as the instrument is dishonored and unless delay is excused, as hereinafter provided, must be given within the times fixed by this Act. Section 103, where parties reside in same place. Where the person giving and the person to receive notice reside in the same place, notice must be given within the following times. A. If given at that place of business of the person to receive notice, it must be given before the close of business hours on the day following. B. If given at his residence, it must be given before the usual hours of rest on the day following. Letter C. If sent by mail, it must be deposited in the post office in time to reach him in usual course on the day following. Section 104, where parties reside in different places. Where the person giving and the person to receive notice reside in different places, the notice must be given within the following times. A. If sent by mail, it must be deposited in the post office in time to go by mail the day following the day of dishonor, or if there be no mail at a convenient hour on that day, by the next mail thereafter. B. If given otherwise done through the post office, then within the time that notice would have been received in due course of mail, if it has been deposited in the post office within the time specified in the last subdivision. Section 105, when sender deemed to have given due notice. Where notice of dishonor is duly addressed and deposited in the post office, the sender is deemed to have given due notice, notwithstanding any miscarriage in the mails. Section 106, deposit in post office. What constitutes? Notice is deemed to have been deposited in the post office when deposited in any branch post office or in any letter box under the control of the post office department. Section 107, notice to subsequent party, time of. Where a party receives notice of dishonor, he has, after the receipt of such notice, the same time for giving notice to antecedent parties that the holder has after the dishonor. Section 108, where notice must be sent. Where a party has added an address to his signature, notice of dishonor must be sent to that address, but if he has not given such address, then the notice must be sent as follows. A. Either to the post office nearest to his place of residence or to the post office where he is accustomed to receive his letters, or B. If he lives in one place and have his place of business in another, notice may be sent to either place. C. If he is sojourning in another place, notice may be sent to the place where he is sojourning, but where the notice is actually received by the party within the time specified in this Act, it will be sufficient though not sent in accordance with the requirements of this section. Section 109, Waiver of notice. Notice of dishonor may be waived either before the time of giving notice has arrived or after the omission to give due notice, and the waiver may be expressed or implied. Section 110. Whom affected by waiver. Where the waiver is embodied in the instrument itself, it is binding upon all parties. But where it is written above the signature of an endorser, it binds him only. Section 111, Waiver of Protest. A waiver of protest, whether in the case of a foreign bill of exchange or other negotiable instrument, is deemed to be waiver not only of a formal protest but also of presentment and notice of dishonor. Section 112, when notice is dispensed with. Notice of dishonor is dispensed with when, after the exercise of reasonable diligence, it cannot be given or does not reach the party sought to be charged. Section 113. Delay in giving notice of dishonor. How excused? Delay in giving notice is excused when the delay is caused by circumstances beyond the control of the holder and not imputable to his default, misconduct, or negligence. When the cause of delay ceases to operate, notice must be given with reasonable diligence. Section 114. When notice need not be given to a drawer. Notice of dishonor is not required to be given to the drawer in either of the following cases. A. Where the drawer and the drawee are the same person. B. When the drawee is fictitious person or a person not having capacity to contract. C. When the drawer is the person to whom the instrument is presented for payment. D. Where the drawer has no right to expect or require that the drawee or acceptor will honor the instrument. And lastly, E. Where the drawer has countermanded payment. Section 115, when notice need not be given to endorser. Notice of dishonor is not required to be given to an endorser in either of the following cases. A. When the drawee is a fictitious person or a person not having capacity to contract and the endorser was aware of the fact at the time he endorsed the instrument. B. Where the endorser is the person to whom the instrument is presented for payment. C. Where the instrument was made or accepted for his accommodation. Section 116, notice of non-payment, where accepted, refused. Where due notice of dishonor by non-acceptance has been given, notice of a subsequent dishonor by non-acceptance is not necessary unless, in the meantime, the instrument has been accepted. Section 117, effect or of omission to give notice of non-acceptance. An omission to give notice of dishonor by non-acceptance does not prejudice the rights of a holder in due course subsequent to the omission. Section 118, when protest need not be made. When must be made. Where any negotiable instrument has been dishonored, it may be protested for non-acceptance or non-payment as the case may be, but protest is not required except in the case of foreign bills of exchange. Section 119. So, Section 119 is covered under the chapter of the discharge of negotiable instrument. Section 119, instrument how charged, discharged rather. A negotiable instrument is discharged. Letter A, by payment in due course, by or on behalf of the principal debtor. B, by payment in due course by the party accommodated, where the instrument is made or accepted for accommodation. C, by the intentional cancellation thereof by the holder. D, by any other act which will discharge a simple contract for the payment of money. And letter E, when the principal debtor becomes the holder of the instrument at or after maturity in his own right. Section 120, when persons secondarily liable on the instrument are discharged. A person secondarily liable on the instrument is discharged A, by any act which discharges the instrument, B, by the intentional cancellation of his signature by the holder, C, by the discharge of prior party, D, by a valid tender of payment made by a prior party, E, by a release of the principal debtor unless the holder's right of recourse against the party secondarily liable is expressly reserved, F, by any agreement binding upon the holder to extend the time of payment or to postpone the holder's right to enforce the instrument unless made with the assent of the party secondarily liable or unless the right of recourse against such party is expressly reserved. Section 121. Right of party who discharges the instrument. Where the instrument is paid by a party secondarily liable thereon, it is not discharged, but the party so paying it is remitted to his former rights as regards all prior parties, and he may strike out his own and all subsequent endorsements and again negotiate the instrument except letter A, where it is payable to the order of a third person and has been paid by the drawer, and letter B, where it was made or accepted for accommodation and has been paid by the party accommodated. Section 122, Renunciation by Holder. The holder may expressly renounce his rights against any party to the instrument before, at, or after his maturity. An absolute and unconditional renunciation of his rights against the principal debtor made at or after the maturity of the instrument discharges the instrument, but a renunciation does not affect the rights of a holder in due course without notice. A renunciation must be in writing unless the instrument is delivered up to the person primarily liable thereon. Section 123, Cancellation, Unintentional, Burden of Proof. A cancellation made unintentionally or under a mistake or without the authority of the holder is inoperative, but where an instrument or any signature thereon appears to have been cancelled, the burden of proof lies on the party who alleges that the cancellation was made unintentionally or under a mistake or without authority. Section 124, Alteration of Instrument, Effect of. Where a negotiable instrument is materially altered without the assent of all parties liable thereon, it is avoided, except as against a party who has himself made, authorized, or assented to the alteration and subsequent endorsers. But when an instrument has been materially altered and is in the hands of a holder in due course, not a party to the alteration, he may enforce payment thereof according to its original tenor. Section 125, What constitutes a material alteration? Any alteration which changes the date, the sum payable, either for principal or interest, letter C, the time or place of payment, D, the number of the relations of the parties, E, the medium or currency in which payment is to be made, and F, or which adds a place of payment where no place of payment is specified, or any other change or addition which alters the effect of the instrument in any respect, is a material alteration. Section 126 is now covered under the Bills of Exchange, Form and Interpretation. Section 126, Bill of Exchange, defined. A bill of exchange is an unconditional order in writing addressed by one person to another, signed by the person giving it, requiring the person to whom it is addressed to pay on demand or at a fixed or determinable future time a sum certain in money to order or to bearer. Section 127. Bill, not an assignment of funds in the hands of a drawee. A bill of itself does not operate as an assignment of the funds in the hands of the drawee available for the payment thereof, and the drawee is not liable on the bill unless and until he accepts the same. Section 128, Bill addressed to more than one drawee. A bill may be addressed to two or more drawees jointly, whether they are partners or not, but not two or more drawees in the alternative or in succession. Section 129, Inland and Foreign Bills of Exchange. An inland bill of exchange is a bill which is or on its face purports to be both drawn and payable within the Philippines. Any other bill is a foreign bill. Unless the contrary appears on the face of the bill, the holder may treat it as an inland bill. Section 130, when bill may be treated as promissory note. Where in a bill, the drawer and drawee are the same person, or where the drawee is a fictitious person or a person not having the capacity to contract, the holder may treat the instrument at his option either as a bill of exchange or a promissory note. Section 131, Referee in case of need. The drawer of a bill and any endorser may insert thereon the name of the person to whom the holder may resort in case of need, that is to say, in case the bill is dishonored by non-acceptance or non-payment. Such person is called the referee in case of need. It is the option of the holder to resort to the referee in case of need or not, as he may see fit. Next chapter is all about acceptance, section 132, acceptance, how made, etc. The acceptance of a bill is the signification by the drawee of his assent to the order of the drawer. The acceptance must be in writing and signed by the drawee. It must not express that the drawee will perform his promise by any other means than the payment of money. Section 133. Holder entitled to acceptance on face of bill. The holder of a bill presenting the same for acceptance may require that the acceptance may be written on the bill, and if such request is refused, may treat the bill as dishonored. Section 134. Acceptance by separate instrument. Where an acceptance is written on paper other than the bill itself, it does not bind the acceptor except in favor of a person to whom it is shown and who on the faith thereof receives the bill for value. Section 135. Promise to accept when equivalent to acceptance. And a conditional promise in writing to accept a bill before it is drawn is deemed an actual acceptance in favor of every person who upon the faith thereof receives the bill for value. Section 136. Time allowed drawee to accept. The drawee is allowed 24 hours after presentment in which to decide whether or not he will accept the bill, but the acceptance, if given, dates as of the day of presentation. Section 137. Liability of drawee retaining or destroying bill. Where the drawee to whom the bill is delivered for acceptance destroys the same or refuses within 24 hours after such delivery, or within such other period as the holder may allow to return the bill accepted or non-accepted to the holder, he will be deemed to have accepted the same. Section 138. Acceptance of incomplete bill. A bill may be accepted before it has been signed by the drawer, or while others incomplete, or when it is overdue, or after it has been dishonored by a previous refusal to accept or by non-payment. But when a bill payable after sight is dishonored by non-acceptance and the drawee subsequently accepts it, the holder, in the absence of any different agreement, is entitled to have the bill accepted as of the date of the first payment. Section 139 speaks about the kinds of acceptance. An acceptance is either general or qualified. A general acceptance assents without qualification to the order of the drawer. A qualified acceptance in express terms varies the effect of the bill as drawn. Section 140. What constitutes a general acceptance? An acceptance to pay at a particular place is a general acceptance unless it expressly states that the bill is to be paid there only and not elsewhere. Section 141. Qualified acceptance. An acceptance is qualified which is a conditional, that is to say, which makes payment by the acceptor dependent on the fulfillment of a condition therein stated. B. Partial, that is to say, an acceptance to pay part only of the amount for which the bill is drawn. C. Local, that is to say, an acceptance to pay only at a particular place. D. Qualified as to time. E. The acceptance of someone or more of the drawees but not of all. Section 142. Rights of parties as to qualified acceptance. The holder may refuse to take a qualified acceptance, and if he does not obtain an unqualified acceptance, he may treat the bill as dishonored by non-acceptance. Where a qualified acceptance is taken, the drawer and endorsers are discharged from liability on the bill, unless they have expressly or impliedly authorized the holder to take a qualified acceptance or subsequently assent thereto. When the drawer or an endorser receives notice of a qualified acceptance, he must within a reasonable time express his dissent to the holder, or he will be deemed to have assented thereto. Next chapter is presentment for acceptance, section 143. When presentment for acceptance must be made. Presentment for acceptance must be made, A. Where the bill is payable after sight, or in any other case where presentment for acceptance is necessary in order to fix the maturity of the instrument, or B. Where the bill expressly stipulates that it shall be presented for acceptance, or C. Where the bill is drawn payable elsewhere than at the residence or place of business of the drawee, and in no other case is presentment for acceptance necessary in order to render any party to the bill liable. Section 144. When failure to present releases drawer and endorser. Except as herein otherwise provided, the holder of a bill which is required by the next preceding section to be presented for acceptance must either present it for acceptance or negotiate it within a reasonable time. If he fails to do so, the drawer and all endorsers are discharged. Section 145, Presentment, how made. Presentment for acceptance must be made by or on behalf of the holder at a reasonable hour on a business day and before the bill is overdue, to the drawee or some person authorized to accept or refuse acceptance on his behalf, and where a bill is addressed to two or more drawees who are not partners, presentment must be made to them all, unless one has authority to accept or refuse acceptance for all, in which case presentment may be made to him only. Section or paragraph B, where the drawee is dead, presentment may be made to his personal representative. And lastly, paragraph C, where the drawee has been adjudged a bankrupt or an insolvent or has made an assignment for the benefit of creditors, presentment may be made to him or to his trustee or assignee. Section 146, on what days presentment may be made. A bill may be presented for acceptance on any day on which negotiable instruments may be presented for payment under the provisions of Section 72 and 85 of this Act. When Saturday is not otherwise a holiday, presentment for acceptance may be made before 12 o'clock noon on that day. Section 147, presentment where time is insufficient. Where the holder of a bill drawn payable elsewhere than at the place of business or the residence of the drawee has no time with the exercise of reasonable diligence to present the bill for acceptance before presenting it for payment on the day that it falls due, the delay caused by presenting the bill for acceptance before presenting it for payment is excused and does not discharge the drawers and endorsers. Section 148, where presentment is excused. Presentment for acceptance is excused and a bill may be treated as dishonored by non-acceptance in either of the following cases: A, where the drawee is dead or has absconded or is a fictitious person or a person not having capacity to contract by bill. B, where after the exercise of reasonable diligence presentment cannot be made. And lastly, paragraph C, where although presentment has been irregular, acceptance has been refused on some other ground. Section 149, when dishonored by non-acceptance. A bill is dishonored by non-acceptance: A, when it is duly presented for acceptance and such an acceptance as is prescribed by this Act is refused or cannot be obtained, or letter B, when presentment for acceptance is excused and the bill is not accepted. Section 150, duty of the holder where bill is not accepted. Where a bill is duly presented for acceptance and is not accepted within the prescribed time, the person presenting it must treat the bill as dishonored by non-acceptance or he loses the right to recourse against the drawer and endorsers. Last, section 151, rights of holder where bill not accepted. When a bill is dishonored by non-acceptance, an immediate right of recourse against the drawer and endorsers accrues to the holder and no presentment for payment is necessary. Next chapter is all about protest. Section 152, in what cases protest necessary. Where a foreign bill appearing on its face to be such is dishonored by non-acceptance, it must be duly protested for non-acceptance, and where such a bill which has not been previously been dishonored by non-acceptance is dishonored by non-payment, it must be duly protested for non-payment. If it is not so protested, the drawer and endorsers are discharged. Where a bill does not appear on its face to be a foreign bill, protest thereof in case of dishonor is unnecessary. Section 153, protest how made. The protest must be annexed to the bill or must contain a copy thereof and must be under the hand and seal of the notary making it and must specify, letter A, the time and place of presentment, B, the fact that presentment was made and manner thereof, C, the cause or reason for protesting the bill, D, the demand made and answer given, if any, or the fact that the drawer or acceptor could not be found. Section 154, protest by whom made. Protest may be made by A, notary public, or B, any respectable resident of the place where the bill is dishonored in the presence of two or more credible witnesses. Section 155, protest when to be made. When a bill is protested, such protest must be made on the day of its dishonor, unless delay is excused as herein provided. When a bill has been duly noted, the protest may be subsequently extended as of the date of the noting. Section 156, protest where made. A bill must be protested at the place where it is dishonored, except that when a bill drawn payable at the place of business or residence of some person other than the drawee has been dishonored by non-acceptance, it must be protested for non-payment at the place where it is expressed to be payable, and no further presentment for payment to or demand on the drawee is necessary. Section 157, protest both for non-acceptance and non-payment. A bill which has been protested for non-acceptance may be subsequently protested for non-payment. Section 158, protest before maturity where exceptor is insolvent. Where the exceptor has been adjudged a bankrupt or an insolvent or has made an assignment for the benefit of creditors before the bill matures, the holder may cause the bill to be protested for better security against the drawer and the endorsers. Section 159, when protest dispensed with. Protest is dispensed with by any circumstances which would dispense with notice of dishonor. Delay in noting or protesting is excused when delay is caused by circumstances beyond the control of the holder and not imputable to his default, misconduct, or negligence. When the cause of delay ceases to operate, the bill must be noted or protested with reasonable diligence. Section 160, protest where bill is lost and so forth. When bill is lost or destroyed or is wrongly detained from the person entitled to hold it, protest may be made on a copy or written particulars thereof. Next chapter is all about the acceptance for honor, section 161. When bill may be accepted for honor. Where a bill of exchange has been protested for dishonor by non-acceptance or protested for better security and is not overdue, any person not being a party already liable thereon may with the consent of the holder intervene and accept the bill supra protest for the honor of any party liable thereon, or for the honor of the person for whose account the bill is drawn. The acceptance for honor may be for part only of the sum for which the bill is drawn, and where there has been an acceptance for honor for one party, there may be a further acceptance by a different person for the honor of another party. Section 162, acceptance for honor, how made. An acceptance for honor supra protest must be in writing and indicate that it is an acceptance for honor and must be signed by the acceptor for honor. Section 163, when deemed to be an acceptance for honor of the drawer. Where an acceptance for honor does not expressly state for whose honor it is made, it is deemed to be an acceptance for the honor of the drawer. Section 164, liability of acceptor for honor. The acceptor for honor is liable to the holder and to all parties to the bill subsequent to the party for whose honor he has accepted. Section 165, agreement of acceptor for honor. The acceptor for honor by such acceptance engages that he will, on due presentment, pay the bill according to the terms of his acceptance, provided it shall not have been paid by the drawee, and provided also that it shall have been duly presented for payment and protested for non-payment and notice of dishonor given to him. Section 166, maturity of bill payable after sight, accepted for honor. Where a bill payable after sight is accepted for honor, its maturity is calculated from the date of noting for non-acceptance and not from the date of the acceptance for honor. Section 167, protest of bill accepted for honor and so forth. Where a dishonored bill has been accepted for honor supra protest or contains a reference in case of need, it must be protested for non-payment before it is presented for payment to the acceptor for honor or referee in case of need. Section 168, presentment for payment to acceptor for honor, how made. Presentment for payment to the acceptor for honor must be made as follows. A. If it is to be presented in the place where the protest for non-payment was made, it must be presented not later than the day following its maturity. B. If it is to be presented in some other place than the place where it was protested, then it must be forwarded within the time specified in Section 104. Section 169, when delay in making presentment is excused. The provisions of Section 81 apply where there is delay in making presentment to the acceptor for honor or referee in case of need. Section 170, dishonor of bill by acceptor for honor. When the bill is dishonored by the acceptor for honor, it must be protested for non-payment by him. Next chapter is all about payment for honor. Section 171, who may make payment for honor. Where the bill has been protested for non-payment, any person may intervene and pay it super protest for the honor of any person liable thereon or for the honor of the person for whose account it was drawn. Section 172, Payment for honor, how made. The payment for honor super protest, in order to operate as such and not as a mere voluntary payment, must be attested by a notarial act of honor which may be appended to the protest or form an extension to it. Section 173, Declaration before payment for honor. The notarial act of honor must be on a declaration made by the payer for honor or by his agent in that behalf, declaring his intention to pay the bill for honor and for whose honor he pays. Section 174, Preference of parties offering to pay for honor. Where two or more persons offer to pay a bill for the honor of different parties, the person whose payment will discharge most parties to the bill is to be given the preference. Section 175, Effect on subsequent parties where bill is paid for honor. Where a bill has been paid for honor, all parties subsequent to the party for whose honor it is paid are discharged, but the payer for honor is subrogated for and succeeds to both the rights and duties of the holder as regards the party for whose honor he pays, and all parties liable to the latter. Section 176, where holder refuses to receive payment supra protest. Where the holder of a bill refuses to receive payments supra protest, he loses his right of recourse against any party who would have been discharged by such payment. Section 177, the rights of payer for honor. The payer for honor, on paying to the holder the amount of the bill and the notarial expenses incidental to its dishonor, is entitled to receive both the bill itself and the protest. Next chapter is all about the bills in set. Section 178, bills in set constitute one bill. Where a bill is drawn in a set, each part of the set being numbered and containing a reference to the other parts, the whole of the parts constitutes one bill. Section 179, right of holders, where different parts are negotiated. Where two or more parts of a set are negotiated to different holders in due course, the holder whose title first accrues is as between such holders the true owner of the bill. But nothing in the section affects the rights of a person who in due course accepts or pays the part first presented to him. Section 180, liability of holder who endorses two or more parts of a set to different persons. Where the holder of a set endorses to two or more parts to different persons, is liable on every such part, and every endorser subsequent to him is liable on the part he has himself endorsed, as if such parts were separate bills. Section 181, acceptance of bill drawn in sets. The acceptance may be written on any part, and it must be written on one part only. If the drawee accepts more than one part and such accepted parts are negotiated to different holders in due course, is liable on every such part as if it were a separate bill. Section 182, payment by acceptor of bills drawn in sets. When the acceptor of a bill drawn in a set pays it without requiring the part bearing his acceptance to be delivered up to him, and that part at maturity is outstanding in the hands of a holder in due course, is liable to the holder thereon. Section 183, effect of discharging one of a set. Except as herein otherwise provided, where any one part of a bill drawn in a set is discharged by payment or otherwise, the whole bill is discharged. Last chapter under the negotiable instrument law is all about the promissory notes and checks. Section 184, promissory note defined. A negotiable promissory note within the meaning of this act is an unconditional promise in writing made by one person to another, signed by the maker, engaging to pay on demand or at a fixed or determinable future time a sum certain in money to order or to bearer. Where a note is drawn to the maker's own order, it is not complete until endorsed by him. Section 185, check defined. A check is a bill of exchange drawn on a bank payable on demand. Except as herein otherwise provided, the provisions of this act applicable to a bill of exchange payable on demand apply to a check. Section 186, within what time a check must be presented. A check must be presented for payment within a reasonable time after its issue, or the drawer will be discharged from liability thereon to the extent of the loss caused by the delay. Section 187. Certification of check. Effect of. Where a check is certified by the bank on which it is drawn, the certification is equivalent to an acceptance. Section 188. Effect where the holder of a check procures it to be accepted or certified. Where the holder of a check procures it to be accepted or certified, the drawer and all endorsers are discharged from liability thereon. Section 189. When check operates as an assignment. A check of itself does not operate as an assignment of any part of the funds to the credit of the drawer with the bank, and the bank is not liable to the holder unless and until it accepts or certifies the check. Last chapter under the negotiable instrument law is all about the general provisions. Section 190, this act shall be known as the negotiable instruments law. Section 191, definitions and meaning of terms in this act unless the context otherwise requires. Acceptance means an acceptance completed by delivery or notification. Action includes counterclaim and set-off. Bank includes any person or association of persons carrying on the business of banking, whether incorporated or not. Bearer means the person in possession of a bill or note which is payable to bearer. Bill means bill of exchange, and note means negotiable promissory note. Delivery means transfer of possession, actual or constructive, from one person to another. Holder means the payer or endorsee of a bill or note who is in possession of it or the bearer thereof. Endorsement means an endorsement completed by delivery. Instrument means the negotiable instrument. Issue means the first delivery of the instrument complete in form of to a person who takes it as a holder. Person includes a body of persons, whether incorporated or not. Value means valuable consideration. Written includes printed, and writing includes print. Section 192, person primarily liable on the instrument. The person primarily liable on an instrument is the person who, by the terms of the instrument, is absolutely required to pay the same. All other parties are secondarily liable. Section 193, reasonable time. What constitutes? In determining what is a reasonable time or an unreasonable time, regard is to be had to the nature of the instrument, the usage of trade or business, if any, with respect to such instruments, and the facts of the particular case. Section 194, time. How computed. When last day falls on holiday. Where the day or the last day for doing any act herein required or permitted to be done falls on Sunday or on a holiday, the act may be done on the next succeeding secular or business day. Section 195, application of act. The provisions of this act do not apply to negotiable instrument made and delivered prior to the taking effect hereof. Section 196, cases not provided for in act. Any case not provided for in this act shall be governed by the provisions of existing legislation, or in default thereof by the rules of the law merchant. Section 197, repeals all acts and laws and parts thereof inconsistent with this act are hereby repealed. Section 198, time. When act takes effect. This act shall take effect 90 days after its publication in the Official Gazette of the Philippine Islands shall have been completed. That's all for the negotiable instruments law. God bless to our studies, and thank you so much.